And then I am broadcasting. Mics are now live.
Thanks, Steve.
I would give it a couple of minutes just to let people pile in.
Sure.
Should we mute our mics if we're not talking, Steve? You want?
It doesn't hurt. So if you want to do that, it's not a problem. For our attendees coming in, we're just taking a couple of minutes to let everybody join the seminar before we start. If you want to post questions and answers, there's a Q&A box at the bottom of your interface that you can use to post questions. And if you haven't gotten your written materials, email Maine Trial Lawyers Association at mtla@mtla.org, and we'll make sure that you get those. I would just give it about 30 more seconds, Chrissy.
Okay, great. Okay, Steve, you think we're ready to get started?
Yes, I think you can go ahead and get started.
Okay, perfect. Thank you everyone for joining us today. My name is Chrissy Mann and I'm a board member of the Maine Trial Lawyers Association. I appreciate you all coming here today. I will be your moderator for today. As Steve just said to some of you, you didn't hear, for those of you that are just joining, there is a Q&A button at the bottom of your screen. The way that we're going to proceed today is each of the panelists are going to speak and we will take questions after each one of them is done speaking. I'll try to keep track of those Q&As and I'll let you know if they've been answered live or I will pose them to the panelists. So certainly ask away. I know that some of you have submitted questions ahead of time, which we will also address. I want to thank the panelists today for joining us. We have Amy Robidas, Audrey Baracchio, and Heather Seasonwine. They are going to be talking today about family law and the new normal, and I think Amy is up first.
Yes, thank you, Chrissy. For those of you who don't know me, my name is Amy Robidas. I am the current, whoa, there we go. That's our first technical difficulty. I just wanted to start it off with that. That way, if Chrissy's cat runs through, she can say it wasn't as bad as what you did, Amy. So I am the current chair of the family law section of the Maine State Bar Association. I have been asked to talk about the stakeholders advisory group that the judicial branch created. The point of the advisory group was to obtain input and suggestions for continuing efforts to address the COVID-19 pandemic as it pertains to the courts. Members included representatives from MTLA, DA's office, AG's office, sheriffs, clerks of court, Maine pretrial services. There were people from the media, county commissioners, all of the people who have an interest in the courts opening back up. It was headed by Acting Chief Justice Mead, who began by recognizing the serious threat of COVID-19 and the challenges with reopening the courts. Each stakeholder was able to present the concerns of their constituents, and Justice Mead made it clear that there's no statewide plan at that point for scheduling cases. Now, after the stakeholders group met on May 14th and then on the 21st. The results or the decisions of the group were just released last night. The judicial branch put out a COVID-19 phased management plan. There's a 15-page document that I believe we included in your materials. If we have not, we will try to get that to you. As I said, it was just put out last night. So quite frankly, I did not have time to read all 15 pages of the phase management plan. If my technology is working, you should be seeing it here. more important, I think, for us, they also put out the phased reopening plan for the courts. And that goes through, it's a 5-phase process. The phases can be implemented statewide, or they can be only in specific courts. So you're still going to need to call or be in contact with your courts to make sure your district, you know what's going on with your district court. However, starting June 1st, we'll be in phase 1. That seems to be pretty similar to what's been going on right now under the current PMO as JC1. Phase 2 is expected to start on June 15th. However, as the document makes clear, it's subject to change, like anything and everything in our new normal. However, important to point out, in phase 2, should everything go according to plan, video and telephone conferences are still going to be the preferred method. However, the courts may schedule and hear some in-person cases during phase 2. Phase 3, similar to phase 2, except there will be grand jury proceedings. Phase 4 is when it'll start to be a little more open, in that all types of cases may be scheduled and heard in person. This is supposed to, as of right now, this is supposed to start the beginning of August. And then phase 5 would be essentially the reopening of the courts. Now, reopening will have some limitations in that the number of people allowed in the courtroom is still limited to 10. There's going to be the screening questions, and social distancing will be required. And all courthouse visitors will need to wear face masks or cloth face coverings. As I said, we'll get this document out to you if we haven't already. The other thing I was going to talk about is the pandemic management orders. However, I believe that most of those are superseded by this new phased reopening. For those of you who don't know where to find them, those are on the court's website. There have been 4 issued. PMO TC1 does include proceedings for child protective cases. So if you're practicing them, you'll want to take a look at that. PMO SJC2 is the order that deals with the 49-day rule for deadlines. I don't know, this is extremely difficult to do a conference where I can't see any of the participants. I have no idea if any of this is relevant to you, but the 49-day deadline was put forth in this pandemic management order. I think it was originally issued on March 30th. It was most recently updated on May 20th. It's still not terribly clear to me or to people I've spoken to. You're going to want to take a look at it, and the best course of action is really just talk to opposing counsel if you can about your deadlines and try to get on the same page about them. If you can't, then you can ask for clarification from the court. PMO SJC3, it is the order that talks about what types of documents can be sent to the clerk's office via email. So you do want to take a look at that. And I believe SJC1 will be superseded by the current phased reopening. However, again, this just came out last night, so I'm not entirely sure how they all will interact together. The next thing I was going to talk about was emergency hearings. So it's my understanding that emergency hearings can still be requested under PMO SJC 1. Bring that up just so you can take a look at, obviously, not all cases can be heard. But if there are family matters that are not being heard, and the attorney or the party believes that there are urgent or compelling reasons that the court should hear the case, you can file a motion. The motion must be served on the other party, and written opposition must be filed within 3 days. So that reduces the response time. This is what the court must determine, these 4 issues before they will schedule a hearing. The nature and the matter, it must be urgent and compelling. The hearing can be held without requiring the presence of additional court staff. The proceeding can be undertaken without requiring in-person participation. And the proceeding can be undertaken without requiring the physical proximity of any participants or placing undue stress on those necessary to the proceeding. From what we've heard, these have been being scheduled. They've been litigated when children, specifically when children are not having contact with one parent. They've been held by video or phone, depending on the court. But again, it's very, very court specific what type of technology your court has available to have these hearings. Uncontested hearings have been rolled out it's supposed to be statewide. Those are being held video or phone. For uncontested hearings, you're expected to file the paperwork ahead of time so that the judge or magistrate has all the orders in front of him or her at the time of the uncontested hearing. The testimony is taken by the parties just the same way as it had been taken live in court. Each of the parties are sworn in, and the attorney can go through the questions. Sometimes some magistrates are asking the parties to confirm the last 4 digits of their social security number to ensure that they are who they say they are. But again, it's not statewide. For the most part, all regions have restarted their dockets as far as we know. And so case management and status conferences are being held mostly by telephone. Those conferences are being scheduled in 20-minute intervals to allow for confidentiality and not overlapping of cases. Unfortunately, the phone system is becoming quickly overwhelmed, and people are experiencing busy signals when trying to call the conference line because there's currently a limit of the number of participants. People are encouraged to just continue calling if you do get a busy signal, and if possible, you can reach out to the clerk to let them know you're having trouble. This will be easier starting June 1st because the courts are going to be reopened to the public from 8 a.m. to 4 p.m. So I expect that the clerk's office will be staffed, not in full, but more than they have been. When you have a status conference, the court will send you the advisory on family matters. A copy of that is also included in the handouts, and it just makes it clear that no person should be appearing in court in person at this time. As for contested hearings, the non-emergency contested hearings, we have some good news about that. The Family Law Magistrate Pilot Program has been approved. This is the administrative order that allows for, again, beginning June 1st, it authorizes the family law magistrates to hear final contested actions for divorces with children, legal separation with children, parental rights and responsibilities. Of course, certain conditions apply. The parties must consent in writing to having a family law magistrate conduct a final contested hearing. And because it's family law, they created a handy form to consent. The form can be found at the Judicial Branch website for all the court forms. It is at the bottom of all of the family law matter forms. Here, FM 236, consent to final contested hearing. One has to be filled out by each party. And it has to be filed 14, so sorry, let me back up. Procedurally, the way that this will be scheduled will be at a pretrial conference where the parties will say, okay, we would like the magistrate to hear this. After that pretrial conference, the parties will only have 14 days to file the consent form. Otherwise, the case will be scheduled to be heard in the normal course in front of a judge. And that's just to make sure that the cases don't languish. In addition to filing the form, the cases, in order for them to be heard by a family law magistrate, they may not take longer than 3 hours, and they are subject to direct appeal to the law court, and they're exempt from the holding in Dietrich v. Dietrich. So that, I took it some good news for the reopening of these cases and getting them to final litigation. The bad news is that the available magistrate time for such hearings is going to vary greatly from region to region. We don't suddenly have new magistrates or a lot of additional magistrate time. So additionally, the court has not worked out the logistics as of Tuesday of this week, at least. The courts have not worked out the logistics of how the hearings are going to be held. Are they going to be video? Are they going to be telephone? Are they going to be different in every region? So while June 1st is the official start date, that goal might be more aspirational, and we should not assume that courts will just be open up for any hearing that we believe is necessary. That is my overview of sort of where the courts are for family law cases at this point. I don't know if anyone has any questions for me specifically.
Yeah, so Amy, we got a couple of questions here. The first one, and some of them about the urgent and compelling issues. The first one is about, what about child support? Is this considered urgent and compelling?
I haven't had that issue specifically. However, I believe that it is being recognized as urgent and compelling if they are not, if a party is not receiving any financial support. I know that when the court is looking to schedule hearings as they reopen the dockets, the judges are asking, judges and magistrates are asking whether or not there is any issue that COVID has presented regarding the finances of the party. And I think that would give them a sort of a heightened urgency.
Okay, and on that topic, and this is addressed to any of the panel members that want to chime in on this, what have you experienced or heard regarding requests for hearings based on urgent and extraordinary circumstances? What constitutes urgent and extraordinary circumstances?
Right, so, and this is really just, you know, from talking to other practitioners. We have heard, I know definitely of one that was held in front of a judge. It was held telephonically. This was in Lewiston, and it was when one parent was completely withholding contact from the other parent. The other motions that I've heard about being filed were usually were either denied outright because it wasn't compelling, or were scheduled for a conference with the magistrate, and the magistrate was able to assist the parties in reaching an agreement during that conference. But Audrey and Heather, I'm happy for them to weigh in if they have something else, or if there's anyone, you know, participating who you know, wants to tell us their story. We are happy to hear that as well.
Yeah. And participants can do that just either by communicating on the Q&A, their thoughts or their experiences as well. And I will share that with the group. The last question, Amy, is why will anyone consent to a magistrate for a final contested hearing if the status quo favors that party?
That's a good question. I don't know. I mean, I suppose that there are, though, a lot of cases where both parties are anxious to just get it done. But I do think that because of COVID, there have been many cases where one person is just at an unfair advantage due to the circumstances. And I don't see any reason why they would agree to that. I don't see anything in the administrative order that can allow a party to be required to agree to it either at this point. So I think that unfortunately those cases are just going to be put in front of a judge. Now, hopefully we'll be getting judge time late summer or early fall.
Sure. Okay, great. Thank you, Amy. That's all the questions for now. I think we're going to move on to Heather at this point.
Thank you.
Thank you, Chrissy and Amy. I'm here to talk about mediations and online mediations. I've done quite a few since this pandemic has started. And initially, things were so unclear and people didn't know what was going on. The mediations really focused on what can we do in the short term, like what's going to happen next week. It was difficult and challenging to do full and final agreements because people didn't know if they were going to be working. They didn't know what was going to happen with their 401ks. So we really initially focused on the short term. Now I'm finding that there is a little bit more certainty. I had a status conference the other day, and we had reached time is so off these days. The opposing party and myself, we had reached a full and final agreement. The magistrate put it on the record. We had already submitted a copy of the divorce judgment signed by the parties. So if you can reach a final agreement, send it to the court. I believe they're willing to take your testimony and your case is over. So again, that's one of the reasons why I think mediation more than ever is important to help move your cases along. It's my understanding that the courts will start to do mediations, but they're having some technical difficulties. So I anticipate that mediations will roll out differently, based on the regions and their capabilities. So I had never heard of Zoom until the pandemic, and I don't like technology. I'd rather have my IT person figure out my computer issues. And so I was intimidated by Zoom, but once I had an opportunity to practice, it's definitely manageable and workable. The first mediation I conducted, the other attorneys and the guardian ad litem were very gracious. We practiced over a couple times, and then we let the clients know that this was our first Zoom mediation, and they were very receptive, and so it actually worked out well. I think that you have to be prepared for glitches, and that's okay. People are understanding and things do happen, but so far so good. I always have the attorney's cell phone number so that we can communicate if there is some type of a glitch that can't be communicated over Zoom, and that's also worked out well. So like any type of practice or mediation, whether it's in person or online, it's an evolving practice. And so recently, a couple of things have come up that have made me, that will impact my fee agreements. One is I had two self-represented clients. There were no lawyers, and they were in the same room sharing the same device. And that worked for a few minutes, and then I made them go into separate rooms. So that was an interesting experience. In a week or two, I have a mediation where there's a PFA between the parties, and so we're not sure how that will impact the mediation. The PFA order says that they can have indirect contact for purposes of court proceedings. So that's something that the lawyers and I will talk about before the actual mediation takes place. So it's important that you prepare your client for a Zoom mediation. Some clients are very familiar with the technology and others are not. So you want to make sure that there's a good internet connection. You want to make sure that they're on a device. A phone is your last resort. It's better to have a computer or an iPad, but we can make a phone work. You want to go over location. You want to suggest to your clients not to be in a car. Don't smoke. I heard there was a video contested hearing the other day, and one of the participants was smoking. You want to talk to them about the camera angle. Most importantly, you want them to be in a private room where children can't run in and out. You won't hear dogs barking, and there is a good level of privacy. Now, doing these Zoom mediations, you really just have to trust the parties that no one else is in the room. There's an SNL Zoom video that you can also direct your clients to about what not to do in a Zoom video. It's kind of funny. So the other thing that I think is important to do is to go over what people should expect in an online mediation, and it's very similar to what you would do in person. So initially I will talk to the parties and the clients, put them in a main room, and then I'll separate them into what's called breakout rooms. So a plaintiff and the attorney will be in one room, and the defendant and the attorney will be in another room. I also like to create a room for the lawyers. If there's a guardian, the guardian may or may not move back and forth in between rooms. The guardian may talk to everybody in the main room together at the beginning, and the mediator can go back and forth into the different rooms. I do have a little demo that we'll show at the end. I'm trying to, it's a little rough around the edges, but I think it will be a good demonstration in terms of how the breakout rooms work. So before I do mediation, I always send out a fee agreement. It can be electronically signed by the parties and the attorneys. At the mediation, we go over the fee agreement, and it's a little bit different. There are particular, whoa. Steve, can you put that on again? Is that showing on your screen? Okay. So as everyone has seen so far, you can do a lot of different things with Zoom. Share the documents. There's a chalkboard you can use. You can do a lot. So it's a great way to share information. So the big things that have changed in my fee agreement is that all the parties agree that the mediation will take place in a where there's privacy and nobody else will be present or can hear what's going on, particularly children. I also now have added language that if parties are in the same location, they will not share a device and they will attend the mediation in separate rooms. The other aspect that has changed with regard to my mediation agreements is that any type of electronic recording is strictly prohibited unless there's some type of an agreement. Sometimes we've agreed that at the end of a mediation, if there is a full and final agreement or an interim agreement, we will record that for purposes of, if there's a disagreement in the future. We also can draft an agreement together online as the mediation is progressing, and then people can sign it electronically, or it can be distributed at a later point for people to sign. And Steve, if you could scroll down a little bit more. The last thing that I'd like to point out on this fee agreement that's designed for online mediations is that you can sign in different ways in terms of making sure that you have an agreement. So it can be done electronically. One person can sign it, email it to me. Another person can sign his or her own, email it to me, and that's considered an agreement that's in full force and effect. So the day of mediation, prior to mediation, I send out a Zoom invitation to the attorneys and the clients. I also send out the fee agreement and some instructions or background information about how the mediation is going to go. At the start of the mediation, everybody is in what's called a waiting room. And I typically don't bring people into the main room until everybody is there. Then we move into the main room. I'll do, the typical, everything in mediation is confidential, et cetera, hit the high points. And then we'll move into breakout rooms. I'll go back and forth. Like I said earlier, sometimes the lawyers will meet in a certain room. We can kick the lawyers out, put the clients in a room without the lawyers. We can do whatever we would do if this was an in-person mediation. The only difference is in an in-person mediation, the mediator gets a lot of exercise. In doing this in front of, the video, I sit here for about 4 hours. So it's important that people take breaks. They ask if they need to take a break. And we try to reach agreements. And if there is an agreement, it's enforceable. And that's basically it in terms of the difference between an online mediation and an in-person mediation. Now, Steve, if you will start this demo, and everybody just remember, this is homegrown, it's a work in process, and it's just here to give you a taste of what the breakout rooms are like. So, hit it. And sign. And then I ask the parties and their attorneys if they've had an opportunity to read the fee agreement, and we usually go over a couple of high points, which would be when you're doing these Zoom mediations, it's really important that nobody records your mediations and that you all are in a private room. There are no children around. Nobody can access your room. So those are typically the highlights that I like to hit. And now I'm going to separate you into breakout rooms. So I have a breakout room for Chris and Julie, and I have a breakout room for Sean and Emily. So I'm going to join Chris's breakout room first, and then I'll join Sean's. You will be in complete privacy, so you can't hear what's going on in each other's rooms, okay? So hang tight.
Okay.
So I've already created the breakout rooms. And so I put Chris and Julie in Chris and Julie's room. And now I'm going to assign Emily and Sean into their room. Sometimes the lawyers like to convene in their own room without the clients. And so I have a room for that too if we were going to use those. Okay, we'll see you in a few. So sometimes it takes a few minutes. Now I'm going to join in Chris and Julie's room. So you hit this button right here. Hello.
Hello.
Can you hear me?
I can.
Okay, excellent. One second.
Steve, I think you could stop it
So
here.
how are things?
So let's do this. You flipped the plaintiff and the defendant, but
It was a work in progress. Okay, so that is all I have. If there are any questions.
So Heather, there aren't any specific questions about mediation right now. There have been 2 submitted online that I think I'll wait till the end after Audrey speaks to have all the panelists respond to. Thank you.
Thank you.
Okay, Audrey, you're up.
All right. So what I'm talking about today is how to keep cases moving when court access is limited. And Steve, if you can start that PowerPoint just on the first slide, that would be great. So one point that I want to emphasize right at the outset here is that we do need to move these cases. So I think when this all began, Many of us thought, okay, it's going to be a month, maybe 6 weeks, and then things will be back to normal. So maybe it's okay for me to let some cases kind of hibernate until the courts are up and running again. But we now know that is not the case. From Amy's updates and from the other things we've been hearing, we know that family cases will not operate the way they used to for a long time, if ever. So it's time for us to think about how to adapt our practices so that we can work with what we've got. So if you can flip to the next slide there. The first category that I have is things that you can do in your office to try and move cases forward. And so the first one is take an inventory of every single case. Hopefully you've already done this, but if not, I think it's really vitally important to sit down and go through each and every active case that you've got. And I did this with my assistant, and we looked at, okay, what is the status of the case? Number 2, we connected with the client. And then number 3, we literally asked and answered the question, what can I do to move this case forward? And then calendared those action items and made sure that it happened. And the reason that this is so important right now is that we aren't necessarily going to have court deadlines and events to push us into action or to remind us of these cases. And so we want to make sure that nothing's falling through the cracks. The next one is take the time for trial planning. You know, I think this time period actually presents a really great opportunity to fully plan and develop your case so that it's in the best position possible for hearing when that hearing happens. So that means not just thinking in advance about your exhibits and your witnesses, but also identifying what it is your client can do with maybe an extra 2 months. That's going to put them in the best position for when a judge is deciding their issues. Develop tech forms and templates. Tech has obviously been a really vital part of all of our practices under these new conditions. This is another area where I think it's helpful to consider for each and every person in your office, what do they need to do what I'm asking them to do? So for example, if you've got a staff person and you're asking them to do some work from home, then you can go through with them, what do they need to do that? And maybe they say, you know, I need a better internet connection. I've got some budget service. It doesn't have the speed or the reliability that you want from me. Or maybe they need a scanner, or maybe they need a printer. And once you go through that, and I know a lot of offices are literally making lists, you know, here's Susan, here's her tech need. Once you go through that, then to actually make that investment and buy those technologies that you need to make this happen. And the reason that it's important to do that now, I know we're all kind of reluctant to spend money right now, but it's an investment for the future, because we've all heard there could be rolling shutdowns for years to come. So even if your staff is coming back to the office next week, you can put the elements in place right now so that you'll be able to keep your cases moving in the future, regardless of what happens. And then also forms and templates. Those are other areas where instead of just slapping on a patch and doing the one thing in front of you, that you can take an extra minute, develop that template that you can use in the future. And that's also a good task for staff. If your staff is a little underutilized right now, that they can work on developing templates or processes that will help streamline things in the future. And then keep your staff connected. I think we often don't realize just how much we lose by not all being in the office together. And we had this come up in my office where one day a staff person was there and the phone's ringing off the hook and she's getting emails from clients with urgent questions and her stress level is just going up and up. And the attorneys are working from home, so we're not hearing the phone ring, we're not seeing her getting increasingly stressed, and so we're sending her assignments as we normally would, and that really pushed her to her limit. And fortunately, we were able to talk and resolve that, but it is something to be aware of. And then also keeping the staff in the loop. So if I'm at home and I'm making a bunch of calls on a case, and then somebody calls the office, the staff person has no idea what they're talking about, that doesn't look very good for me. And that's the sort of thing that just, if we're all in the office, it happens kind of naturally because they're overhearing the phone calls and they're seeing what I'm working on. But when we're separated, it's not happening in that way. And so we really have to make an intentional effort to make sure the staff's in the loop and that they're connected, and we're checking in with them to make sure that they're getting what they need and that their workload's okay. So on the next page here, I've got some tools that attorneys can use to help keep cases moving. I imagine you've heard of most of these. So we've got the obvious Zoom. And since this is a Zoom webinar, I'm assuming everyone has some familiarity with it. But I did include in the materials a little step-by-step guide with screenshots on how to set up a client meeting in Zoom, in case that's helpful for anyone. And most of the attorneys I've talked to are finding Zoom really useful, as Heather said, and I'm finding it very useful for client meetings, especially for new client meetings, where it can be important for them to see me face-to-face and for me to see them, as we're trying to decide if we're going to work together for the next year or 2 years or forever, as family cases sometimes seem to go. Task apps. What I'm talking about there are apps that let you create and organize to-do lists. And you can set deadlines, you can set reminders, and the key feature is that it syncs across all your devices. So work computer, home computer, cell phone, assistant's computer if you want it, all of those will be in sync so that you've got access to those lists and to those reminders wherever you are, and you don't have to go find a file somewhere at one location. Phone number forwarding. So I know an issue a lot of people are encountering is if they don't have someone in their office all the time, they're checking their messages maybe every 3 days, hopefully a little more frequently than that, but that can present some issues. And so whatever phone service you're using, there is the ability to forward phone calls and or voicemails to your cell phone without just giving out your cell phone number to the clients or the other attorneys. And it varies a little bit depending on what phone service you use, but this is a really good time to figure out how to do that. Again, even if you're not going to use it right now, you might want this for the future. So look into it now, know how to do it, and then you'll be able to act quickly if, a month down the road, the governor says, all right, everybody go home by 8:00 p.m. and don't leave your home for the foreseeable future. You'll know what to do to be able to get work phone calls and try to keep your business moving. And then there's been a similar issue that people have encountered with mail. Again, if you're only checking it every few days, recently the courts have been sending scheduling notices with a very tight turnaround. And so that can be an issue sometimes. So USPS informed delivery. I know this is something Chris Largay has talked about in some of these webinars. But what that is a free service of the Postal Service. I have no idea how they're able to do this, but they do, where they'll take photos of the front of each envelope that they're delivering to you that day, and they'll email it to you. So you can look at that and say, okay, I got a piece of mail from Bangor District Court that's probably on the Smith case. That's something I should probably go in and take a look at what that is. If you can flip to the next page there, Steve. So the next topic is things you can do with your clients to keep cases moving. So we've got redirect focus to settlement or temporary agreements. Why not work on settlement or temporary agreements right now? And you can take that time that maybe you would have been spending preparing for an interim hearing and spend that drafting a proposal or really trying to move these cases forward. And a lot of attorneys I've talked to have said they're having very frank conversations with their clients right now, saying, look, if you don't want to be in the same situation 18 months from now, now is the time to start thinking about compromises, start thinking about concessions, and think about how you can get your case done. Check in with clients regularly. That kind of goes without saying, but it's another thing that sometimes you have to kind of do very intentionally and remind yourself to do. So at the beginning of all of this, I called all of my clients to check in with them about their case, and then also to give them the current best information that I had about the courts and what we can reasonably expect in the future. So trying to manage their expectations right from the outset. And then if I'm not naturally going to be talking to those clients a lot going forward, then I have calendared so that at regular intervals, I'm calling them again to check back in. And I've heard from other people that that's really helping a lot with client satisfaction during a time that's something to worry about. Give clients tools to help decision making. There are going to be some tools on the next page that you can share with them. And then keep clear documentation to back up your client's decision making. So a big outstanding question here, I think, for many of us is, will the courts hold parents responsible who take advantage of the situation to withhold kids? And, it's a fact that judges are going to have a really hard time distinguishing between actions taken from legitimate concerns and pretext. But there are things that we can do to more clearly illustrate that for them. So for example, if you're representing the parent withholding the kids, then you want to work with them to identify their specific concerns, about the conditions at the other parent's house, or whatever the most specific concerns you can get are. You want to lay out a path of what that other parent could do that's going to address those concerns. And then also encourage the client to offer alternatives in the meantime. So if you're not sending the kids for their weekend visit, then make sure you're offering very liberal video contact or something like that. And then you want to document those things, and you want to communicate all of that to the other parent. So when you're in front of a judge later, you can say, look, here is the specific thing that my concern was based on. I gave the other parent an achievable way to resolve that, and I made sure that they maintain that connection to the kids. So this was not just me trying to cut them out of the kid's life. And then you can imagine how that would work from the other direction if you're representing the other parent. And then on the next page here, we've got tools. This is just some things that you can share with clients if you think it's going to be useful to them to help them in their thinking. The court has an FAQ page that's linked there that's specific to family matters, and that has some basic helpful information for clients. And then the next page, please. All right, and so the next one is things you can do with the court to try and keep these cases moving. So we've got take action to start deadlines running. So some deadlines have been extended, some haven't. It's confusing. Regardless, you want to start that clock ticking. So if you can get a party served, to do it. If you can initiate discovery, get it going. We are getting discovery conferences, and we have been getting discovery conferences. So there's no reason why you can't be working the evidence side of your case. Be thoughtful about hearings to use court time wisely. We're getting very limited hearings. Even if it's going to be by video or by phone, it's going to be limited. So you want to make sure that you're taking that time for the things that you really need a judge for and what you really want to get out of them during that time. And then consider alternatives to in-person hearings by the court. So Heather talked about the mediations, which is a fantastic tool. I've heard from attorneys who are trying cases by reference, and that's been very helpful to getting things done. Some attorneys are getting telephonic judicial settlement conferences, which may or may not be helpful depending on your case. But we do have options. There are other options, even if you can't have a in-person court hearing like we're all used to. And then the final slide here is overall adapt. So to return to my message from the outset, we have an obligation to our clients to adapt and to move their cases forward. So rather than wait and be forced into things kicking and screaming, your practice and your clients, I think, will benefit from a mindset where you jump in and you make those changes now that are going to let your practice thrive under the conditions that we're going to have to deal with into the future here. So if people have questions, or also I can see from the list of attendees that we've got some very experienced practitioners here. So if people have other tools that they've used or thoughts they want to share, I think we'd be really happy to get those as well.
Yeah. Thank you, Audrey. There are a couple questions that have come in, and I think it pertains primarily to the coronavirus. And you touched a little upon whether people were taking advantage of withholding their children. The question that came in on the Q&A is, have any of the courts held hearings involving parents who don't agree on the interpretation of the governor's orders, specifically how it relates to social distancing, quarantining, and withholding children due to concerns about the coronavirus spread? And is this something that they have considered urgent and compelling?
So I haven't heard about many of the hearings. As Amy said, there apparently have been some around the state. It sounds like those are happening in cases, though, where a parent completely cuts off contact. And please correct me if I'm wrong, Amy. And that's why I suggest, if your client is going to be the one not allowing visits, then they should make sure that they're offering alternatives so that they're getting themselves out of that zone, hopefully, where a court might consider it an emergency. Did you have thoughts on that, Amy?
Nothing except to echo what you've said. From what I've been hearing, and my practice is mostly in Cumberland and York counties, if parties are allowing video contact at this point, I'm not seeing a big move, or some sort of contact to keep the child and the other parent connected. Then I'm not seeing now this is all prior to today, and with the reopening of the courts, we might be seeing more of them. But at this point, it's been sort of it seems like the courts understand that some people are just hunkering down, and as long as there's video and phone contact happening, they haven't really opened the floodgates to allow people in to litigate it.
Okay, and I'm going to chime in here because one of the other questions we received actually via email was just how you guys are approaching this issue with your clients, I think, where there might be a parent that's not trusting the other one to do appropriate health protections for a child about the coronavirus. I think you're kind of commenting about that as well, but if there's any other additional information you wanted to provide.
Yeah, so I've got, kind of my generic response to clients about, the governor's order doesn't prohibit travel for, for visits, and you've got to remember your child has 2 homes, and they're going to be a little bit different. But yeah, when it comes down to it, I think that's what I talked about, all right, working with clients to make sure that their concerns are really specific and trying to back it up too. So if their concern is that the child is in some way going to be exposed, in some particular way, well, is that something we can ask the pediatrician? Is that an actual risk to worry about or not? And so where you can get that kind of backup, that can help with the clients and trying to make sure that they're reasonable so that they hopefully don't get dinged later. But also setting it up for that documentation for the future. But I think we have to accept that this is a situation where reasonable people can differ in their approaches. And the courts probably aren't going to come down really hard on people who are earnestly trying to do the best things for their kids. And so you just want to make sure that you're identifying that and making that as clear as possible, that is what your client's doing, and that's what's motivating them. I don't know if anyone else had thoughts in response to that.
Well, a new question that just came in was, what about parents coming in from out of state for visits with the 14-day quarantine order? Can the other parent insist on it?
The other parent being the out-of-state parent?
I would assume so, yeah.
I have had this experience with a client coming from New York, and the magistrate has said that the quarantine does not prohibit travel into the state. However, she also, in that specific case, suggested that the parties meet halfway. I don't know. I mean, I think that if you have a client who is saying, you know, that the out-of-state parent cannot come and have contact in Maine, I think that the 14-day quarantine supports that, in that they are not allowed to go out in public. However, if the parent wants to come and pick the child up and immediately turn around and leave the state, I think that my reading and understanding of it is that is completely acceptable. So you would not be able to use the quarantine as an excuse to withhold contact in that situation.
And I think there's clarification here. A participant said, no, can the in-state parent require the 14-day quarantine?
Prior to seeing the child, I don't believe so.
Okay.
That is, from my experience, limited experience, again, the quarantine is for individuals going out into public, and this would fall more under a parental rights decision. If the out-of-state parent is saying, I'm safe and healthy, I've been doing my minimal quarantining at home, I want to see my child, I don't see how the in Maine parent uses the 14-day quarantine to prohibit it. But I think this is something that judges are going to be deciding in the future.
Right, and I think the participants also adding that the order doesn't provide for out-of-state contact.
I'm not sure I understand. So if the order says that out-of-state parent has to come here and see the kid only in Maine, then I think that out-of-state parent has a problem, because where are they going to see the child? They can't go, they're not supposed to go out in public. But I think there are creative ways around it. But again, and I think this goes back to what Audrey said, is if your client is the one saying no, make sure you're making documentation, you're documenting exactly why and what other options you are providing that parent who's losing the contact.
The next question has to do with the stimulus payments. Has the court made any rulings regarding the division of COVID-19 stimulus payments to divorced or divorcing parents?
And I can take this. So we talked about this a little bit before this seminar, and none of us on the panel have heard of courts making any rulings on that yet. I don't know if any of the participants here have had different experiences. And so, you know, it is a tough issue that I think we're all dealing with our clients. Officially, the stimulus payments, it's my understanding, are considered to be a prepayment of the 2020 tax credit. So that gives you a little bit of guidance on how to think about it. You're at least supposed to think about it for 2020. But of course, you know, they're paying it based on past taxes. And so that doesn't help you too much, you know, when it comes to the money's been deposited into somebody's account. So, you know, what I've been doing with that is, you know, at the very least, preserve it as an issue for final hearing, just like you would a tax refund that's in dispute. But then if you can, trying to come up with some agreement for it. I've been trying to tie it to expenses that affect both the parties, or an expense for the child if we're talking about the child's stimulus payment. And so sometimes that can help to just resolve that issue. But I think you also want to try and at the time, see if you can reach agreements for future payments. Since there might be future payments coming in, say, okay, you got this one, how about I get the next one? Or how about the next one goes to paying the cost of summer camp for our child or something like that.
And someone is sharing that at a panel of New Hampshire judges in family cases, they unanimously considered the stimulus payments to be income for support purposes, at least under New Hampshire's broad definition of income. A next question is, what about removing the child to a hotspot by airplane for the coming summer with no information relating to what the situation would be in the hotspot?
Well, you guys can feel free to jump in. I think, again, the court hasn't given us anything clear. So I think the same general advice applies. And, our clients are going to do what they need to do or what they think they need to do to protect their kids. I'm not going to be too pushy with a client and say, you should expose your kid to this danger that you're very concerned about. Of course, I'm going to tell them, well, the order says this, and you're supposed to follow orders, and here's the things that can happen if you don't. But I would hesitate to say, if they say, I'm not sending my child, I don't think I'm going to push them terribly hard on that if they've got these specific reasons again. So I think that goes back to the general advice of, look, your client's going to do what they need to do. Just try to work with them and push them to make sure that they're making the most justifiable and backed up decisions that they can.
Great. Well, I see that we're kind of running against our hour time that we were trying to keep it within. I did want to share another comment from the participants that regarding buying new equipment that I think you discussed, Audrey, the PPP loan program will likely be modified to allow expenditures to be made for that, along with extending the time from 8 weeks to 16 weeks to make expenditures that will be forgiven. So obviously that's something that's constantly changing and we all need to probably keep an eye out for. I want to thank everyone. I want to thank our panelists for their time today. It was greatly appreciated. And on behalf of the Maine Trial Lawyers Association, this concludes the CLE. Thank you so much, everyone.
Thank you, Chrissy.
Thank you.